Okay, good afternoon, and welcome to the second and final part of our Powering Texas CLE series focusing on the Texas Energy Fund. For those of you who had joined our first installment last week, welcome back. And for those of you who are joining for the first time, we are pleased to have you. My name is Winston Skinner, and I'm an attorney in our energy regulatory group here in Austin. And for the past 18 months, my colleagues and I have been focused on really all aspects of the Texas Energy Fund, from its legislative inception to its voter approval in November, to the agency implementation by the Public Utility Commission of Texas, and now to the ongoing application and due diligence process for financing new thermal power plants here in Texas. As many of the loan program applicants know, the PUC's rule effectively creates a few different requirements relating to environmental submissions on behalf of an applicant. One is submission of a Phase 1 environmental site assessment. Another is a list of required environmental permits, including both air and water as applicable. And the third is an air emissions compliance plan, including evidence of any required air emissions credits. Today, if we can go to the next slide, I'm pleased to present an overview with a couple of my colleagues on how to obtain and defend environmental permits relating to air quality. And to that end, I'd like to introduce two of my colleagues, Eric Groton and Patrick Traylor. Eric is a senior partner in our environmental group in Austin. He has nearly 40 years of experience representing clients and helping them navigate all aspects of state and federal laws relating to air quality. And that includes emissions rights transactions, permit applications, enforcement actions, and legislative and agency advocacy. Patrick is also a partner in our environmental group based in Washington. And after a distinguished tenure at the US EPA, where he led nationwide Clean Air Act enforcement on the civil side, he has overseen clients in a wide variety of environmental enforcement actions, internal compliance investigations, and permit applications. So we're pleased for them both to be joining us today. Now, without further ado, I will kick it over to Eric to begin the discussion on air quality permits. Eric, take it away.
Well, thanks, Winston, and good morning or afternoon or evening, as appropriate to wherever you are. And thanks for joining us. There's quite a range of roles and responsibilities related to power project development represented, I think, and those of you joining the call, and some of you have little or no direct permitting responsibility, and be thankful for that. And some of you who are just absolute permitting experts. That's your day in, day out job. We have, in fact, I think we have some of the best permitting consultants in Texas on the line as well. Well, with that range, it leaves me somewhat at risk of providing little or no new information to some of you and maybe too much to others. So I ask for patience and forgiveness, both ends of that spectrum. But what we do all have in common is an interest in what it takes to get permission to build a fossil fuel fired power plant in Texas. And why should you be interested in that? I mean, among all the variables and costs and risks associated with project development, why are we dedicating a whole program in our Energy Fund series to air permitting? Well, that's because air permitting is often the rate limiting step on the Gantt chart towards getting to project completion, and because the requirements to get a permit can significantly affect project design or even viability. And that becomes truer, generally speaking, in proportion to project size and scope. But I'll start very simply. Under the Texas Clean Air Act, every source of air emissions in Texas needs permission from TCEQ. And that includes like even your backyard barbecue and your home water heater. But before you start worrying about getting fined for grilling without a license, please know that Texas law also provides for the permission that you probably didn't even know you needed through something called a permit by rule. And that's all part of a system in Texas, which has been doing air permits since before 1970, and it's evolved quite a bit. But it's set up a system where the type of permission you need and the process to get it and the demonstrations to get it vary somewhat logically in accordance with the type and size and complexity and location of the source, which is as it should be. Um, but having all those various means of getting permission to emit something into the air of the state of Texas, uh, just it means that there's not really one answer to the question of what does it take to get permission to build a fossil fuel power plant in Texas. Um, the maybe go to the next slide, please. There's as I mentioned, a hierarchy of mechanisms to get that permission. And the list that's presented on this slide is in increasing order of uh, the demonstrations required and the complexity of the process, the amount of public involvement, costs, and the degree, and most importantly, perhaps the degree of agency discretion, and again, public involvement that go into getting them. Uh, the easiest ones to get are at the top. The ones at the bottom are hardest to get. The ones at the top you might get without even knowing you've applied for it, and the ones at the bottom can take, 3 or more years and millions of dollars to get. So let's talk a little bit about the generally speaking what these four categories of air quality permits are in general before applying them to specifically to uh, options for power project permitting. Um, The first permits by rule, they used to be known as standard exemptions. There was a list that the agency published, starting in the early 70s of things that they thought were sufficiently trivial that you shouldn't have to get a permit for them, even though the Texas Clean Air Act says if you emit something into the air, you need permission. Um, some decade or decades ago, though, the agency realized that calling them exemptions was not really correct. They need to have forms of permission. Plus, if from the public standpoint, calling them exemptions sounded like like the agency was letting people get away with something. So those are now called permits by rule, and um, those all are codified in Chapter 106 of the Texas Chapter Title 30 of the Texas Administrative Code. You go to Chapter 106 and you see a whole litany of um, I think there's there are probably around 130, 150 different sources and circumstances under which you are granted a permit by rule. And some of them are just one-liners that say, for example, your grill is permitted. Um, and then some of them are much more involved, but they say you are permitted. For example, you can build a large storage tank, but there's limits expressed in the permit on the volatility of the material and so forth. So permits by rule cover a lot of different things, um, but they don't cover anything that is um, but there are also statutory and regulatory limits on the annual emissions that can be authorized through that mechanism. Stepping up from the permit by rule, again, which are all codified in Texas Administrative Code, we have standard permits, and there are actually two types of standard permits, which are a relatively new feature in the Texas Clean Air Act landscape, going back maybe 20 years or so. There's two forms of them. One are the so-called adopted standard permits, which, like the permits by rule, are published uh, in the Texas Administrative Code at subchapter F of Chapter 116, as indicated there. Um, but there's very few of those, and the agency is moving away from going through the obligating itself to go through a rulemaking process to adopt these permits. Instead, they're going through they issue them. They're called non-rule standard permits, and there is you pretty much have to just go to the website, the TCEQ website, and the issued standard permits are there. The commission does go through a process of adopting and issuing them that's analogous to rulemaking, but it's not quite rulemaking, and the permits don't get codified. And as we will see, this option has significant relevance to many of the projects of interest to you on the phone today. Um, the important part about standard permits is that um, they do not require any case-by-case evaluation from the agency, except to confirm that your facility is of the type that is eligible for under the terms of a standard permit. But the standard permit, as its very name suggests, is standardized. There are terms, detailed terms, the conditions are already made up. And if you're building a type of facility that is within the terms of that standard permit, you get it after filing a registration form. The agency does have to review and confirm and send you back confirmation that your project is eligible for that standard permit, but there's no meaningful direct public involvement up front. And there's very little, if any, agency discretion. So a much easier form than the next category of permitting, which is what one typically, the conventional permit, sometimes known as a minor new source review or NSR permit. It's what one typically thinks of when you think of a permit. It's a detailed application with a lot of information about the project, its location, design, flows, material balances. You have to include case-by-case demonstrations of uh, compliance with various permitting requirements. And then the agency has substantial discretion, both in terms of uh, what, uh, well, whether to issue the permit and especially under what terms. Um, and The fourth category is for major sources, which require either, depending on the nature of the air quality at the proposed location, whether the area is in attainment or not in attainment of national ambient air quality standards, affects whether or not a major source requires either prevention of significant deterioration or so-called PSD review, or whether it's subject to non-attainment new source review. But as a major source, the requirements become much more significant and onerous, as we will see as we discuss them specifically as applied to power project permitting. Um, of all these four mechanisms are all quite different, but they all have essentially the same objectives. In fact, can we have the next slide, please? One way or the other, either baked into the adoption of the rule, the permit by rule when it was first adopted, or the standard permit, or in the course of case by case agency technical review of either a conventional permit or a major source permit. Um, the agency ensures that the project is applying control technologies, and meeting emission limits consistent with applying control technologies that are um, appropriate or even the best for the kind of source that you're proposing to build, considering cost and effectiveness and amount of emissions and so forth. So there's a control technology review element to all permits, and there is an element of also making sure that, okay, you're applying the best controls, but are those best controls still going to be sufficient to protect ambient air quality? That's something that's also a consideration baked into uh, permits by rule or those case by case reviews. And that's done through, usually it's based on dispersion modeling, where you use computer programs that assess what a certain amount of emissions will mean from a plant at in the ambient air. Well, if you emit 10 pounds an hour of some organic, well, what effect will that have on air quality outside the plant? That's again done through dispersion modeling. Um, the And then lastly, this is also baked into the permitting process. The agency wants to make sure there's innumerable other air quality related obligations associated with facility operation. Those are Patrick will take those up uh, as we in just a moment or two here. But the idea is to make sure through permitting that you're authorizing a project that's going to meet the other air quality requirements. Um, the Well, let's now talk about how this hierarchy of permitting options applies to projects that are in or want to be in the Texas Energy Fund, which of course ranges from internal combustion engines to simple cycle turbines to combined cycle plants, not including, it does not, so far as I know, include anybody who's still want to build a coal-fired power plant, um, which is one of the funnest and more challenging things I've had the opportunity to do over the years. But and the projects also range from, a few hundred to over 1,000 megawatts. And there are some on the chip channel, and there's some on the opposite end of the state. Um, how does all that affect the kind of permit that you need? Um, well, first, let's look at the options for using permits by rule. So that would be on the next slide, please. Next slide. There we go. Uh, we used to have the option of using a permit by rule for stationary engines and turbines, but that's no longer available. The agency decided that that source category needs the additional protections and agency oversight of the standard permit process. So you can't authorize the the guts of your project through a permit by rule anymore, but permits by rule are still relevant to permitting um, to permitting gas-fired power projects because it's a typical means of authorizing individual facilities as well, not just the turbines or the engines, but the tanks and you can authorize maintenance, startup, and shutdown emissions. You can authorize black start generators and other small the ancillary pieces of equipment through permits by rule. Um, Next slide, please. Um, the the option I hope that's available to all of you that are either in the process of or considering project development under the TEF is that you're eligible for this standard permit. The standard permit that was uh, this is one of those issued standard permits. You have to go to the TCEQ website to find it. um, I don't expect you to write it down, but we will have these slides available. The link is posted there for where you find that standard permit. What you'll find when you look at it is it's very useful for authorizing uh, uh, reciprocating engines that are gas fired or turbine based generation, but it's not useful for boilers and a heat recovery steam generator, as an element of a combined cycle plant is considered regulatorily a boiler. So you can't use this standard permit directly to authorize a combined cycle plant, but you can if the HRSG isn't fired, it's not a boiler, and therefore you don't have to worry about it. Or if it's fired, but I think under maybe 40 million BTU, um, then it's eligible for for one of those permits by rule that we were just talking about. So there are ways of doing a combined cycle plant using the standard permit. To get it, it just requires a registration and a $900 fee payment, and it is deemed approved by operation of law if the agency hasn't looked at it for 45 days and doesn't respond to your application. So there are ways of managing the time risk associated with permitting by going through the standard permit process. The standard permit for electric generating units for these for gas-fired engines and turbines um, includes pretty minimal requirements for monitoring, reporting, and record keeping. It obligates the project permittee to meet the otherwise applicable rules that, again, Patrick will talk some about. And it does impose a NOx limit that effectively compels the use of selective catalytic reduction, or SCR. And even though it doesn't require carbon monoxide controls, most folks are going to want to use and apply CO catalyst to their projects so that the emissions of CO2, sorry, of carbon monoxide don't have the effect of triggering review as a major source, because any meaningfully sized combustion source is going to emit quite a bit of CO. And if you get, as we will see, if you get those CO emissions above either 100 or 250 tons, you can radically change the requirements for your permitting. So that's the standard permit for um, electric generating units. There is, I should very briefly point out on the next slide um, that well, actually, I'm not sure where that slide went, apologize, but there is another standard permit forthcoming that that the agency has proposed, one of those issued non-rule standard permits for uh, it applies only though to engines, and it's been proposed by the agency, but not fully adopted, and it won't affect the ability to use uh, the standard permit that we've been talking about. So it remains to be seen whether it will be a useful tool or not. But we don't have to really worry about that until early next year. So if you still have a project that you're trying to figure out how to authorize by early next year, check back in and see if maybe that new proposed but not yet final standard permit might be a useful option for you. Um, okay, sorry. Now next slide, please. Uh, no, let's go back. There we go. Um, so your best option again is likely going to be this EGU standard permit from 2007. If you look on the slide here, it identifies a number of projects that were that fell within the authorizations granted by those standard permits and have been authorized. And these are not, I mean, these are decent size peaking operations. Including one that's six almost 10 megawatt Jensbacher engines, one that was almost 120 megawatt. I'm sorry, 350 megawatts of engine power. What you see there is that the bigger it gets, the more you have to start considering putting hours of operation limits on your assets so that they don't trigger that major source threshold. That's something that has to be done through legally enforceable limits. And so if you're going to try to build as this company did, a peaker plant that comprised of 16 21 megawatt man engines, the permittee figured out that it has to limit itself to an average of 5,000 hours a year of operation. Otherwise, that would become a major source. But with those limits, it stays below the 100 tons, sorry, 250 ton threshold, and was able to be permitted with a standard permit without, in a matter of weeks, not years. Next slide, please. We've talked about the new non-rule standard permit. Okay, now as we increase in scale and obligation, we get to conventional permitting, which, as already mentioned, is the traditional file a detailed application, include case-by-case demonstrations of the adequacy of the control technology, include modeling, dispersion modeling sufficient to show that the authorized emissions would be protective of the innumerable air quality standards that would apply. Um, and once you get the application submitted, shortly after you submit the application, you do an initial public notice um, of intent to obtain a permit, um, and that's filed or published shortly after filing the detailed application. The agency then goes through a technical review phase, which can go 4 to 6 months and sometimes more. Um, You have to establish to the satisfaction of the assigned TCEQ air permit engineer that you're meeting the requirements on and they're again discretionary. What's the best available control technology? I mean, there's some standardization involved, and the agency has lots of procedures in place to sort of manage the discretion that would otherwise apply to an individual permit engineer. But there is still a great deal of discretion that goes into it, and hence the time and a lot of back and forth. Um, and occasionally negotiations of what the proper limits are in your permit. Um, the and that is then taken into account in the actual conditions of the permit that the permit engineer develops. Um, and then you have to pay in order to get that permit, you also have to pay an application fee of up to $75,000. You get there pretty quickly. I think with the capital cost of a little over 2 mil, you're already at the maximum fee. And then with any conventional permit, you have to get to the possibility anyway, because you've notified the public of the filing of the application. You're also notifying the public that it has certain procedural rights, including the right to file written comments, the right to have a ask for and get a public meeting, sort of a legislative type gab session about the permit in a public forum. And you're also opening up yourself to a request for contested case. Next slide, please. And again, we'll talk a little bit more about what's involved with the contested case here in a minute. Um, but as we get to the last rung on the ladder, the one that's the most precipitous, is for major source permitting. And that basically means we'll put aside questions about whether you're adding your project at an existing site, in which case the questions of major modifications may pop up. But if you're building on a greenfield site, basically, then you just need to be worried that you're not building a major source, or at least be aware if you plan to. And that just means that your project has the potential to emit more than 100 tons or more than 250 tons, depending on the category of source. The Clean Air Act, the Federal Clean Air Act, and then hence the state programs that are built to meet the requirements of the Federal Clean Air Act have a list of a little over 20 so-called categorical sources, which are the ones to which a major source threshold of 100 tons applies. And that includes fossil fuel fired steam electric units. It doesn't include simple cycle turbines or engines. And the EPA has concluded, and TCEQ, I think follows along, I know follows along with this, is that if you are creating steam to make power, such as you would in a heat recovery steam generator in a combined cycle plant, um, you are a categorical source and therefore subject to that 100-ton limit or 100-ton threshold for making your source a major one. But if you are, again, the simple cycle turbines and engines are not categorical sources. They get a 250-ton threshold, and that can be extremely helpful. Used to be a much more complicated question, but now, after a lot of dust has settled in the Supreme Court, um, one triggers PSD review, major source review for greenhouse gas emissions, only if you are otherwise major for another non-greenhouse gas pollutant, and the requirements are not meaningfully changed really by having to get to tack on greenhouse gas reviews, although it may be becoming more complicated as we start having new rules governing greenhouse gas emissions from power projects. Um, there's more notice and public participation requirements potentially applicable if you trigger PSD. Your modeling analysis to support the demonstration of acceptable air quality impacts includes a so-called increment analysis, where you look at how much you're increasing existing levels of air pollution in an area, rather than just meeting the national ambient air quality standards. The EPA and TCEQ require that you also establish that you're not making the air significantly dirtier than it was before your project was there. That's done through, again, these increments, which are small amounts of allowable increases in existing air and existing pollution levels. There's a little bit more obligation to use EPA-driven methods, and the fee that you very quickly get to the maximum fee of 75,000 because you're basing it on a 1% of the capital cost. Again, in the scheme of things, the fee is not a big deal. Next slide, please. The one rung on the ladder you really don't want to be on is being a major source and being major for a pollutant for which the area is non-attainment. If you trigger non-attainment new source review, which happens if you're in a severe non-attainment area, such as exists now in both the Houston and Dallas areas, and multiple counties around those metropolitan areas, the major source threshold is very low, and you really don't want to trigger major source review in a non-attainment area. The main problem is the requirement to obtain offsets, which is reductions in pollution from other sources that are in the area that go below or beyond what the source would otherwise have to do to meet its obligations. So you're basically having to pay someone else to reduce their emissions by at least as much and sometimes more than what you're planning to emit. And there used to be, Houston's a little bit easier. It's more industrialized, and therefore there are more sources. But Dallas is a huge challenge. So building in those in or near those urban areas is potentially very problematic, which is why we're seeing a lot of the projects go in just on the outside of those non-attainment areas. Not surprising, and that's exactly what the rules incentivize. The other thing that's challenging about another thing that's challenging about non-attainment new source review is that the limits are based not on some judgment about what's the best available controls, but what's the lowest achievable limit. And if you get thrown into that level of control technology analysis, you're going to have people throwing, somebody spent way too much money in California to get something built, but now it's proven to be something somebody has done somewhere for a lot of money. That then becomes something you have to do to get your permit. You have to also demonstrate that you considered other sources or other locations for your project that weren't in the non-attainment area. That's the alternative site analysis that's mentioned in the slide in front of you. And then you also have to demonstrate that all your sources elsewhere in Texas are in compliance. So it's a huge, sometimes really almost always impossible burden. If you fall into the non-attainment new source review trap, you might not get out. Next slide, please. For any conventional permit, so for those conventional minor NSR permits, and certainly for the major ones, the public allows you, or the statute obligates the commission to create the opportunity for affected persons to request a contested case. And that's the subject of another entire webinar. But if you're close to the plant and you raise issues that are relevant to air quality permitting, you get the opportunity to ask for and almost invariably obtain a so-called contested case, which means that after the agency's executive director and her staff has completed all of their technical reviews and said your permits application's great, here's the conditions of the permit, not so fast. You still, at that point, then either you go to the commission will refer the matter to the State Office of Administrative Hearings because there are unresolved requests. And there's a process to go through to decide for the commission to evaluate those requests, or the applicant can simply conclude, as often they do and should, that there's somebody's gonna get a hearing here. Let's just let's get it over. When I say get it over, it's over to the State Office of Administrative Hearings, which is a separate agency in the state of Texas that has a bunch of administrative law judges, and they serve to review and hold these mini sort of, well, not mini trial, they're trials on your permit application. It's a little bit less formal than a bench trial in, district court. There's pre-filed direct case testimony instead of, putting your own witnesses on and asking them all their questions. You just put them on and turn them over for cross-examination. But other than that, it's like a bench trial. There's, discovery subject, to Texas rules and some administrative rules. Your witnesses are sworn. There's cross-examination. The rules of evidence generally apply. Obviously, lawyers are involved. And you go through this process. The administrative law judge hears the evidence, issues a proposal for decision to recommend the to recommend to the commission what it should do with the objections to the permit. And then that proposal for decision then gets passed along to the commission, which in open court decides whether to adopt the ALJ's proposal or refine the proposal and issues a final order. And it's the commission then that is making the final decision on your permit application. This whole process adds many months, usually a year or more, and a lot of dollars to the permitting process. It's because of the possibility of a contested case with either conventional minor NSR or major permitting, that if you're having to file one of those, you should do your dead level best not to be communicating with or causing communications to occur with appointed commissioners, because that will create ex parte problems. The commissioners are supposed to not hear about anything about your project unless and until it comes to them in the form of a proposal for decision. And you can blow your project up if you have prematurely or otherwise inappropriately contacted one of the commissioners. The other thing I will say about where you have a permit application where there's a risk of contested case, or where there is a substantial likelihood or certainty of public opposition. Shameless plug here, get your lawyer involved early and often to help manage the flow of information and the possibility, and to maintain privilege as you develop applications and information and evidence that's potentially all subject to discovery in the contested case. It's good to have your lawyer involved early to help manage that. Next slide, please. After the commission makes its decision, or the executive director, if it doesn't go to contested case, there are, as you might expect, opportunities for judicial review, and we'll just pass on that. That's next slide, please. Some of you may be wondering, what does TCEQ versus EPA do in this process? It's pretty much just the TCEQ that manages air quality permitting in Texas. So it's a so-called SIP-approved program, meaning that TCEQ acts instead of EPA, and EPA doesn't have any special legal rights in the proceedings, but EPA does have substantial influence nonetheless over what TCEQ does or decides. Because it can threaten, approval of the program. It can threaten an individual case to, okay, go ahead, TCEQ, issue that permit, but when it comes time to get the Title V permit for this source, we're going to object to it. Well, that's enough incentive for both the agency and the applicant to try to resolve EPA's problem. On very rare occasion, the EPA can sue the source owner if EPA said, we didn't like your permit, we don't think it's valid or sufficient. It can sue you for then building your project under an invalid permit. That's something that the Supreme Court opened the door to 20 years ago in a Justice Ginsburg 5-4 opinion in the case it's referenced there. And again, though, thankfully, that's not a weapon they wield very frequently. And then the EPA also, of course, can sort of make TCQ or the applicant look bad by issuing by creating negative comments about how TCQ is doing its job. Um, and EPA does have a much more direct role to play in Title V operating permits. Title V operating permits are the tail on the permitting dog here. It's something you apply for before just before he commencing operation, and it may take years to get, but it doesn't affect your ability to either build or operate your facility. It's a mechanism for EPA or for the government to collect a bunch of fees and to nominally anyway go through and make sure that it issues a permit that codifies otherwise applicable requirements, which includes the requirements of your construction authorizations, whether it's a PBR or a standard permit or a regular permit or a major source permit, and to codify all the other requirements that apply, which is the subject of Patrick's time today. And so I will yield to him and maybe come back for questions towards the end.
Well, Eric, thanks for that review of permitting in Texas. I want to change topics just a little bit here. Next slide, please. So what Eric just covered is what is known as case by case or site-specific pre-construction permitting. And Eric went through all the different ways, particularly in Texas, where one would go about securing those pre-construction authorizations. In addition to that, and I mean, in addition, separate from that, there's a whole body of federal regulatory law that applies to what are called, that applies categorical standards, so-called categorical standards. These are federal regulatory limitations, emissions limit, work practice standards, and so forth that apply to specific categories of air emission sources. And they apply regardless of the kind of pre-construction permit that one might be able to obtain. So if you get a PSD permit, if you have one of these categories of sources at your facility, the categorical standard is going to apply. If you're able to build your source using a permit by rule or a standard permit, nevertheless, these federal regulatory programs, if you're building one of these categories of sources at the site, where they're going to apply independently of the kind of permit that you obtain. Now, there is some overlap because your permit application, your pre-construction permit application, and then of course, as Eric just mentioned, eventually your operating permit, well, it will have to include all of these categorical standards to the extent that they apply. So the permit is going to reference these standards, but the source of the requirement is apart from and separate from permit. In fact, you'll see a number of these categorical standards, particularly those that apply to existing sources. Well, they apply regardless of whether you need to go to an agency and get a permit or not. So I just wanted to start off by contrasting the pre-construction permit programs under the Clean Air Act, which Eric has just covered in excellent detail, from these categorical standards. Okay, now with that kind of separation in mind, I thought that I would just go through, we're not going to go through all these. I just wanted to give you the list of typical ones of these categorical standards that might apply to an electrical generation unit that is being constructed. We could spend an entire day going through all of these in detail. We're not going to do that. What I'd like to do instead is just touch on a few of them because there are a few of them that could be impactful to the timing of construction and the commencement of operation of a new EGU in Texas, or may have some traps that would be relevant to making economic and financial decisions about what kind of facility to build, how big a facility to build, and so forth. So let me just focus on just a few of these. Let's talk about what are called the New Source Performance Standards, NSPS for short, subpart TTTA. Those of us that do air law, we call this the Quad TA rule. And these are the new CO2 standards, the new GHG standards for electrical generation or electric generating units. And I saw in the chat that one of the participants had a question. Well, here we are. Here's the answer to the question. How does permitting fit in with this? This is the NSPS Quad TA. And interestingly enough, it is a very aggressive rule that requires new sources. It also applies to existing sources, but we're not going to talk about that part of the rule. We'll just talk about new sources. It applies to new combustion turbines, so natural gas fired, and I suppose also diesel fired, but I'm thinking more about natural gas fired units that are larger than 25 megawatts that are connected to the grid. So combustion turbines greater than 25 megawatts that are connected to the grid. EPA divides those kinds of sources into three buckets. EPA treats baseload units differently from intermediate load units, and those differently from low load units. So by baseload units, EPA is really thinking about combined cycle natural gas turbines. So the gas turbine associated with a HRSG, or heat recovery steam generator. EPA's new rule has two phases for CO2 standards. Phase one is fairly easy to comply with, and you comply with it just by using natural gas and a well-designed gas turbine and HRSG. However, beginning in January of 2032, that gas turbine, that combined cycle gas turbine, must be retrofitted with carbon capture and sequestration systems. So a new combined cycle unit being constructed after May of 2023, by the early part of next decade, will need to be retrofitted with CCS. Well, that is a very controversial position for the EPA to have taken, to require the use of CCS in these sorts of applications. I think reasonable minds could differ as to whether CCS is available at scale for these kinds of systems. Industry says that it's clearly not available at scale. EPA insists that it is. That dispute has gone to the DC Circuit, which is the appellate court here in Washington, DC. The industry petitioners asked the DC Circuit to stay the rule pending the completion of the appeal. The DC Circuit refused to stay the rule, which means that it is still in effect. Industry petitioners and some states have now appealed, but not really appealed the DC Circuit's ruling, but they've also petitioned the Supreme Court to stay the rule pending the disposition of the appeal on its merits. The Supreme Court has not yet ruled on that petition for a stay. You'll recall that the Supreme Court several years ago stayed one of EPA's power plant rules on the major questions doctrine. So I think that petitioners are hopeful that the Supreme Court will also stay this rule. But for now, it is effective and active. And if it survives judicial review, combined cycle gas plants will have to retrofit with CCS in the early part of next decade. For intermediate, peakers, peaking turbines, simple cycle turbines, it's easier to comply with the rule. You don't have to do CCS. You just have to build a good, well-designed peaker. However, you can only use it up to 40% of its capacity factor, which means that anyone who's planning to build one of these things has to understand that its utilization will necessarily be limited If it goes more than 40% capacity factor utilization, guess what? It has to install CCS. And then low load are sort of very small units below 20% capacity utilization. The only requirement there is that you essentially use natural gas as the fuel. This is probably the most important, I think, of these federal regulatory categorical standards that are applicable to new units. And I want to make sure that I touched on that one specifically because that rule can be so important to early planning for the kinds of facilities that one might go and construct. There's also a hazardous air pollutant rule that applies to combustion turbines. Let me just briefly touch on that one. It is we call those NESHAPs, National Emission Standards for Hazardous Air Pollutants. And subpart quad Y applies to combustion turbines that are located at a major source of HAPs. Now, Eric described what's a major source of non-hazardous air pollution. The Clean Air Act defines HAP major sources a little differently. A HAP major source is any source that emits equal to or more than 10 tons per year of any individual HAP, or 25 tons per year or more of any accumulation or combination. Typically, you don't see natural gas fired combustion turbines located at a major source of HAPs. Those kinds of facilities just don't generate that much by way of HAPs at a greenfield site. But if it's co-located with an older site, if you co-locate one of these things at say a coal-fired power plant that actually might be a major HAP source, you would have to consider this NESHAP subpart quad Y, which has a limitation on the amount of formaldehyde. That's the HAP that is regulated under quad Y. So that's the other combustion turbine rule. One last combustion turbine rule, and that is back over to the NSPS, New Source Performance Standard, quad K. Quad K imposes nitrogen oxide and sulfur dioxide limitations on combustion turbines. Well, those are the federal standards that are most clearly applicable to combustion turbines. We see, however, that a number of the proposed projects in Texas use engines, though, not turbines. And by engines, I mean like reciprocating engines, reciprocating internal combustion engines. Some of them are diesel. Maybe some of them are fueled by natural gas or by gasoline. Spark ignition ones versus compression ignition engines. If you have a facility that employs an engine, there are different NSPSs and different NESHAPs that apply. So, for example, subpart quad I apply to compression ignition engines. Subpart quad J apply to spark ignition engines. And then you have NESHAP subpart quad Z, which apply to both compression and spark ignition engines to the extent they are located at a major source for HAP, and in some cases at an area that is non-major source for HAP. Well, look, I promised that I wouldn't go over all these in detail. I just want folks that are planning projects and evaluating projects to understand that in addition to the permitting requirements that Eric went through, sources and funders and financiers need to be very closely focused on these additional federal regulatory programs, these NSPS and these NESHAP standards, because they can impose meaningful restrictions on how these facilities can be operated. One last comment: EPA also promulgated what's called the Good Neighbor Plan. It's a cap and trade program that is intended to address interstate ozone pollution. That rule is stayed in the state of Texas, and unless that stay is lifted, at least right now, there is no requirement to comply with the Good Neighbor Plan. Well, with that, I will stop this part of it. We may have time for a couple of questions other than the one that I've already answered. Thanks everyone for attending.
All righty. Well, thank you very much to Patrick and Eric for walking us through all things related to air permits. As they mentioned, we have a minute or two more for questions. If you have them, please type them in the chat now. And while we wait on any potential final questions, I will again just reiterate the Energy Regulatory Conference that we're hosting at our Houston office. Again, that's on November 14th. It's an all-day affair. If you have received an invitation and want to attend and have not yet RSVP'd, we encourage you to do so. If you have not received an invitation and would like to attend, then please email me at wskinner@velaw.com and we'll get you signed up. All right, final questions, going once, going twice. I do not see any, so we really appreciate everyone joining. Again, if you have additional questions on the Texas Energy Fund at all in any really respect, please reach out to one of us and we'll be happy to address them. And with that, we thank you all for joining and hope you have a great rest of the day. Thanks.